Hello, friends. Yesterday, we had a very useful discussion in Chennai about Section 65B in an event organized by Cyber Society of India, led by Mr. Balu and Karthikeyan. Several eminent legal personalities had participated, and we had a lengthy discussion on the Section 65B of Indian Evidence Act, whether it is required or whether there is a time to review the existence of Section 65B at all. During the discussions, I presented a viewpoint that as per the Supreme Court decision of Anwar versus Bashir, where it was stated that the Section 65B certificate is mandatory for admissibility of any electronic document, is also a view which I have been holding for a very long time. The reason is that every electronic document is a binary sequence and nothing else. Whether we consider an electronic document as a text document, a video or audio, ultimately the document is nothing but a binary sequence interpreted by a computer device in a particular manner. The interpretation depends upon the device used, the software used for converting the binary sequence into an electronic document. Therefore, when a judge is presented with a binary document, if he has to take a view on whether it is a fact to be admitted as evidence or not, there is a need to convert the binary into a human experienceable form of text to sound or something, what we can hear, what we can see, and so on. And because this conversion is dependent on these devices, and the choice of the devices is made by the person who wants to have that human experience of the binary sequence, we say that ultimately a human being is responsible to say what a particular binary document is. And that person is the person who under Section 65B should be a certifier, who says that whatever is the binary document which I wanted to see, I saw that through a computer using such and such an equipment, using such and such a software, and I was able to see something which I have captured as a printout. This human intervention is absolutely essential to ensure that there is accountability for the conversion of the binary sequence into a human experienceable document. So that is the essence of Section 65B, and that is why we say Section 65B certificate is mandatory. But there is a section of legal personalities who feel that making Section 65B certificate mandatory is hindering the trial process, because today judges are asking, whenever an electronic evidence is produced, they will immediately ask for Section 65B certificate, and otherwise they are not admitting the document. This is hindering the progress. So therefore, they feel that because of this practical difficulty, something should be done to dilute this Section 65B. People have been quoting this Arjun Pandit Rao judgment, and that is the reason why I thought I should clarify what Arjun Pandit Rao judgment says, because some people feel that this Arjun Pandit Rao judgment of Supreme Court states that where there is a so-called original electronic document in the possession of the court, there should be no need for Section 65B certificate. So this raises the question of what is a original electronic document, and whether this so-called original is something similar to or is same as what we perhaps otherwise call as primary document in the case of other documentary evidence. So the concern which has now come up to be addressed is whether Section 65B certificate is mandatory or not, and where there is a original electronic document, then is Section 65B certificate is excused. So I am only trying to look at this limited point in this short clarification, which I thought I should provide for this particular incident. Okay, there are the query which I was hearing yesterday. We didn't have the time to actually go through the clarifications after lunch. So I thought I will try to take this opportunity to speak about that. Now, this Arjun Pandit Rao judgment has two parts. The first part is the one where the three judges have given a common judgment, and second part contains Justice V. Ramasubramanian's additional comments, which is the later part of the judgment. So if you go to the end of the judgment, you will see Justice Ramasubramanian's final conclusion, where he says that it will be clear from the above discussion that the major jurisdictions of the world have come to terms with the change of times and the developments of technology and fine-tuned their legislations. This fine-tuning is with reference to some countries trying to remove the Section 65B kind of certification and going by a more generic description of admitting evidence just like a paper document. Whereas in Indian law, we consider electronic document is a separate kind of evidence as compared to oral evidence and documentary evidence. Now, therefore, Ramasubramanian stated that there is a need at this point of time to relook Section 65B of Indian Evidence Act, and this was a comment he made. So he suggested that there is some issue with the current Section 65B and it has to be relooked. Okay. While arriving at this, he has made some comments, including the difficulty of presenting the Section 65B certificate when the document may not be immediately available in original form, and so on. So otherwise, he has accepted whatever was the general judgment of the three judges. Now, these three judges together came to the final judgment, which is the operating part of this judgment, which was actually a reference made about an earlier judgment. And this, under para 72 of this judgment, says that Anwar judgment, as clarified by us here in above, is the law declared by the court on Section 65B of the Indian Evidence Act, which means that whatever the Anwar versus Bashir case said, which included a comment that it is mandatory for production of Section 65B certificate, stands even after Arjun Pandit Rao clarification. In between, there was some judgments in which a debate was made on the discretionary powers of a judge to admit an evidence, and all that has been discussed in this Arjun Pandit Rao judgment, and then it is said that they are not stating the law correctly. Then under 72 para B, the final view of the judges is mentioned, and it says the clarification referred to above in this particular case, which was whether the Shafi Mahmad and other these things should be taken or something like that, is clarified here under section 65B, whether it is unnecessary to have a certificate if the original document itself is produced. So one condition this particular 72B indicates is that maybe this is acceptable, provided the owner of the laptop or the computer tablet, whatever is the device, has presented the so-called original document to the court. So in effect, one can interpret this as saying that if the document presented is not the original device, then section 65B certificate is mandatory. And if it is original, the original document is presented, then perhaps one should be able to excuse it. Now, this particular situation was also part of the discussion once we had in a court, where the judge felt that even if we have that original so-called device in which an electronic document is contained, it is better to actually have an external person come and view that and then give a certificate under section 65B. If the judge himself puts the device, like let us say he has got a container of electronic document in the form of a hard disk, if he himself connects it to his computer, then runs say Windows software on a Dell computer with the BIOS of whatever is there, and then he uses a Word or say some Windows media player as an application, then looks at what is appearing on the screen and accepts that as evidence, then who is responsible for this method of conversion of the binaries, zeros and ones, to what the judge is seeing on the computer or the screen? Now, who is the person who decides that he should use a Windows computer, that he should use a media player or something like that? So the choice of the device, choice of the software, which is essential for the conversion of the binary into a human experienceable form of the document, is the choice of the judge. Therefore, he becomes part of the evidence creation. So that is why we say that the judge, even when the particular container of the document is presented to him, should ask somebody to actually give a section 65B certificate on the electronic document, because what is submitted as a hard disk is not the electronic document. It is a container in which hundreds and thousands of documents are there. Out of those thousands of so-called documents, one document is what we are looking at as an evidence. And if you look at it technically, it is a sequence of bytes present in one sector of the hard disk platter. And that is what is called the evidence. And that evidence humans cannot view except by converting it into various other, by using various devices into a screenshot or something like that. So therefore, section 65B requiring a mandatory certification is something which even Arjun Pandit Rao judgment cannot say is not required. Because if a person hands over the hard disk, that is not the end of it. There is no evidence. It is like a trunk being given to the judge, and the judge will have to still ask, please open the trunk and show me what is the evidence. So at that time, section 65B is required. The only difference is that now it is in the custody of the court, and if the court wants, they can ask one of its own accredited experts under section 79 capital A to come and open that trunk of documents and use whatever software appears to be appropriate, and then ask that 79A certifier to provide a viewpoint about what is this evidence. So the need for Section 65B certificate does not vanish just because the container of the hard disk and a container of the electronic document is presented. One more point which came up for discussion yesterday is that people were asking, what is this original? If I type a letter out of a computer, do I have to get Section 65B certificate? This fact is something which can distinguish a original from something else. That is, for example, we use the terminology primary evidence in certain cases as distinguished from original evidence. Now, the question is whether the two are one and the same. Now, for example, if you take books, a copy of, say, every copy of a printed book is actually something which can be a primary evidence. A photocopy thereof could be a secondary evidence. Then what is the original? Is every book a original? Then can there be multiple copies of originals? If I have printed 10,000 copies of the book, are there 10,000 originals? Or should we consider the printing plate as the original? These are the questions which we have come across in the physical world also. Now, in this electronic world, what is original is the first digital imprint, which is captured by the device which recorded a particular event. Event could be, let us say, if you are talking of a CCTV footage, the image gets into the CCTV recording device, which is more in all computer cases, there is a possibility that image, the document may first go through a sort of a temporary storage and then go to a final storage. Even if it is in the same device, there are two sections like the RAM and then the storage device. Once it goes into that device, let us say that is the original equipment, there is a card in this camera, and that card is the first imprint of the image. Now, when you take out that card from the camera and then put it into a computer, then you are looking at a second copy of that. Now, in this case, it is like the book which has got a plate, and then you have got the first copy, second copy, third copy, like that. So you may say that this original card is, which contains the first imprint, is the original. Rest of it is perhaps a copy of the original. Now, when it is presented as an evidence, if this card is presented as evidence, again, the judge can do nothing with this card, because that card is again only the container of a digital record. It is not the evidence itself. Therefore, he has to again use a card reader and then view it. Maybe the difficulty arises because in a physical world, if you are taking a printed letter, the letters are completely embedded onto the paper sheet. You cannot pick up the letters and segregate it from the paper. You cannot just pick the letters and leave a blank paper behind. But in the case of an electronic document, if you have got a hard disk surface in which there are some zeros and ones, you can transfer these zeros and ones exclusively into another electronic surface, and as if you can segregate the surface of where the zeros and ones are recorded from the zeros and ones. And that is the reason why when we are having this original document in the, say, the CCTV's card or something like that, you can pick out the digital data from there, transfer it to the computer, and then subsequently any number of times you can transfer and retransfer. In such a scenario, there is some difficulty in distinguishing what is original, what is primary. Definitely between primary and secondary, there is no distinction as far as the electronic document is concerned. And if there is original, that original is contained in a container, and the court can have the possession of it, but to view that and convert it into an evidence, it still has to be read through some device, and the person who reads it through a device is the person who has to give a section 65B certificate. That is the reason why I say section 65B certificate is mandatory in all the cases, even after Arjun Panditrav's judgment. This is basically the clarification I wanted to discuss. If any of you have got any further questions, I would like to hear about it. Limaya is here and Balu is here, Ramesh is here. Is there anything other than this which you would like to actually question? Dr. Limaya, if you can speak.
Sir, my interpretation about this judgment is whenever original device is available and the person gives that evidence before the court, and subsequently if he wants to produce that device later on, then also court will believe on that particular evidence subject to bringing that original device to the court, because it has happened in one of the cases where mobile recordings were transferred and those were produced before the court, but device was not at that time available with the gentleman, and court allowed him to present that device subsequently, and then made that evidence as a primary evidence. So Arjun Pandit Rao is read by different courts in their own perspective, but what they have made specifically clear is that if original device is produced, means original evidence is available along with the device, then certification can be done away. What 65 B4 says that certification is mandatory. So in case of original device is available and that device is capable of showing the content, like in case of mobile phones, if device is capable of showing those images to the judge or examiner, etc., then certificate of that device is means performing perfectly, etc., etc., need not be required. That is what court is right now understanding as far as 65B is concerned in the context with Arjun Pandit Rao judgment.
Yeah, my question to that is, if let us say in a physical scenario, let us say there is a murder, say weapon, which is seized from some house, which in a box. Okay, the box contains several daggers and other things, and that container is brought to the court and said, here is the evidence. Now, is it not necessary for somebody to pick out that particular dagger and say, this is the evidence of murder? Likewise, when a hard disk is presented to the court, I accept that it contains the original. Okay. But is the entire hard disk the original evidence? Obviously not. One portion of that is the original. And can the judge view that original? He cannot view that original by his X-ray eyes on the hard disk. If it has to be read, it has to be read through a system. Now, somebody has to choose the system and somebody has to choose the software. I am saying that that decision to choose, for example, I've given an example regarding a binary, which could be a text or it could be a number. Now, if you are using a binary to ASCII converter, you will see it as a text. Binary to numeric converter, it will be a number. So whether the judge will view it as a text, which is a natural thing which for anybody to do, or whether he will view it as a number, depends upon a decision, a human decision. I am saying that human decision is required before converting any binary into a electronic evidence. Now, if a mobile or something is presented, the court may say that at the admissibility stage, you have presented what you call as the original. We are in a position to call some expert subsequently and view that. Therefore, we will go ahead with the trial. If that is the contention, then you are accepting the container as a provisional say method of accepting the admissibility of one of the documents which may be contained inside, subject to a section 65B certificate being given on a later date. Because most of the courts have held that section 65B certificate can be given during any part of the trial proceedings. So admissibility of an electronic document should be considered as different from admissibility of the container of electronic documents, is my point of view. And what we are talking of as original is presented to the court essentially means that a laptop has been dumped at the court, but to open the laptop, to run it, there are certain things to be done, and that is the process which a section 65B certifier can record and then become a human witness to the process by which the binaries were converted into the human experienceable text or number. This is the thought which I have, and because of which I am saying that section 65B is mandatory, and this talk of the original is actually something which is slightly confusing, because original can be only a container. Nobody can present zeros and ones and bring it to the hands of the judge because it's an intangible aspect. Zeros and ones can only be recognized when it is appearing on a hard disk surface or something like that. So since we cannot segregate the hard disk surface from the zeros and ones, the two are always presented together. But content is different. The container is different. That is why when a person is a owner of the content, then there is no section 65B certificate required. For example, I type out a letter from my computer. I type a leave letter in Word, take a printout, and then I want to submit it. Now, because I am the owner of the content, I have to only sign there yours faithfully, and there is no section 65B certificate. Now, this is the real concept of original evidence. That is, original evidence means the person who is presenting the evidence is the owner of the content. If so, then section 65B certificate is not required. But if it's a third party, this thing, for example, I have typed out a resignation letter and kept it in one computer, and tomorrow the question of evidence is whether I had submitted an evidence, resignation or not, and you view the computer and you find out that there was one Word document which is talking of resignation, and you give a certificate saying that when I viewed the hard disk of this computer, there was a Word document which I have given a printout here. That requires section 65B evidence. Now, because you are not the owner of the content, you are only the owner of the process, and after that process, you submit that to the court, and the court will interpret whether it is a resignation letter or not.